Good afternoon, everyone. Thank you for joining us today. My name is Ann Dalton. This is the ADR the Alternative Dispute Resolution Practice section. We are offering a CLE today. Suzanne Boy has been kind enough to offer to educate us mediators on employment law issues that can come up in mediation. She is interested in having a very lively conversation. So I'm sure that you all have a bunch of questions or a bunch of thoughts you'd like to join in on. This meeting is being recorded. It will be available on the local bar YouTube site in case you have friends or others that wish to watch it and were unable to join us today. So I'm not going to introduce Suzanne. We all know her, and I would actually ask her to provide her own introduction about the things we need to know about her. Thank you, Suzanne, for coming today.
Awesome. Thanks, Ann. Thanks, everybody, for being here. Just before, Ann, you go off, you can see my screen okay? Okay.
Yes, ma'am.
Thanks, Bob. I see you shaking your head too. Good afternoon, everybody. As Ann said, I'm Suzanne Boy. I won't bore you with my long website bio, but I am board certified in labor and employment law. I've been practicing now for almost 15 years. Spent a long time working at Henderson Franklin, and then almost 3 years ago, struck out with John Agnew and John Potanovic to form Boy Agnew Potanovic. Now practice here along with those two Johns, another John Miller. Recently, Vicki Sproat joined us, and we just hired an associate on Monday, Katie Cook. So we focus primarily on employment law. In the employment law world, we only do what we call management side employment law. So we don't ever represent the employee. And I usually, when I'm asked to explain what I do, I take just a couple seconds to say my practice really is divided up into two parts. It's, litigation, which most people would assume correctly that we do. So we defend our employer clients in any kind of employment related litigation you can think of: discrimination, harassment, wage hour, non-competes, whistleblowers, FMLA. The other side of my practice, and the side that I actually enjoy more, is the counseling side. So that's the side that allows us to work proactively with our clients to resolve workplace related issues, terminations, disciplinary actions, leave issues, COVID issues, vaccine issues, hopefully resolving them on the proactive end so they can avoid ending up on the litigation side of our practice where no employer really wants to be. So that's me in a nutshell. When Ann asked me to present on employment law issues and mediation, I wasn't quite sure what you all would be interested in. So the way that I set this up was essentially a sort of a basic overview on employment law, on the issues that we see most commonly, and then a couple of tips on what I think mediators should know with respect to employment law. And then we should have time at the end if recording has stopped. So if you've heard me speak before, you know that I tend to really like doing memes and cartoons. And I often joke when I'm presenting that and you all know as lawyers, being a lawyer is great. It's not always as exciting as people think it is on TV or in the movies. So when I get out of my day-to-day grind and Google sexual harassment e-card or discrimination cartoon, I take the opportunity to do so. So you will see quite a few of those as we move forward in this presentation. So employment law in 2021. This meme perfectly represents the way that I have been feeling and the way that I think a lot of my colleagues and HR professionals have been feeling. It has been a long year and a half for everybody, but it's certainly been a long year and a half for HR, employment law, employers, businesses, as we all try to navigate this wonderful pandemic and all of the fun new legal changes and challenges that's brought with it. I joke with my team, this is an actual card or a copy of a card that from gifts that we got our staff in January to begin the new year. And I found this, what I thought at the time was a very funny card because we were ending 2020, ending the first year of the pandemic, and thought, 2021 is going to be just fine. And so cheers to 2021, what could possibly go wrong? And I only half-heartedly joke that I feel like I jinxed the entire year for everybody. So I already told our staff, you will not be getting cards at the beginning of the year that say anything like this. All right, so as I mentioned, we're going to talk about the basics of employment law, talk about some of the most common claims that we see, a few tips. I might have more than 5 because I came up with an additional one as I was getting prepared, but 5 things I think mediators should know, and then audience Q&A. I will try to, I don't know if I can see the chat. Yes, I can. I'm almost afraid to click things, but if there are questions that you want to throw in the chat, you're welcome to do that, and I will look at the chat before we end and try to answer any of those. And then I assume we'll be able to open it up, audibly for questions at the end. But in any event, hopefully I can help you through any questions that you may have after the presentation. Okay, so basics of employment law. So one of the initial concepts that we always address, when we're talking about the basics of employment law is at-will employment. So I oftentimes get questions from clients, especially smaller clients who may not be familiar with the ins and outs of employment law or who may not have been through the litigation process. Well, isn't Florida at-will employment? How can this person sue me? Florida's at-will employment. Well, yes, that is true. So Florida is an at-will employment state. What that means is that either party may terminate the relationship at any time for any reason. And then the kicker is what I've got here in red, so long as that reason is not prohibited by law. And that's where all of the challenges come from for employers in Florida. So yes, we have an at-will employment state, but that doesn't necessarily mean that you get to terminate, without any kind of risk or recourse. The very basic example that I always give, is you can terminate somebody because you don't like the color of their socks, but you can't terminate somebody because you don't like the color of their skin. So that reason would be prohibited by law. If you've ever had the joy of hanging out with an employment lawyer at a cocktail hour or HR professional, we love to talk in acronyms. We have a ton of them in employment law. And of course, thanks to COVID, we've had some new ones enter our world. So I often try to define these when I speak about the basics of employment law, because it is a good, I think, overview of some of the laws that we deal with. Many of them I think you'll be familiar with, some of them maybe not so much. We've got the ADA and the ADAA. So that's the Americans with Disabilities Act and the Americans with Disabilities Amendments Act. That's the law that protects individuals with a physical or mental disability in the workplace. There's also other sections of the ADA that protect public access, all the lovely ADA accessibility lawsuits that we see with websites and restaurants and things of that nature. But in the employment law world, the ADA protects individuals who are disabled from discrimination and provides them with certain opportunities for accommodations in the workplace. The ADEA is the Americans with the Age Discrimination and Employment Act. That's the federal law that prohibits age discrimination. I often ask when I do supervisory training if anybody knows what the minimum age is for age protection under the federal law. And I typically will get something like 55 or 60 or 65, something like that, but it's actually 40. So one has to be at least 40 years of age to be protected under the federal age discrimination law. Another little fun tidbit for you for your next cocktail hour is the Florida Civil Rights Act, which I actually don't have up here as an acronym, but the Florida Civil Rights Act protects age as well and does not have a minimum age limit. So anybody of any age can be protected theoretically under the Florida Civil Rights Act. FLSA is the Fair Labor Standards Act. That's the federal law that governs wage, hour, and overtime. USERRA is the Uniform Services Employment and Re-Employment Rights Act. That is USERRA. That's the protection for military service. The NLRA and the NLRB, National Labor Relations Act, National Labor Relations Board. Those are typically thought of, and they are primarily union-based, a law and the board. However, there is a provision of the NLRA that applies to private workplaces as well. It's called Section 7, and that has to do with concerted activity. So even a private employer can be governed by the NLRA when it comes to protected concerted activity. And we'll talk about that when we get to retaliation. The EPA in the employment law context is the Equal Pay Act. So you must pay individuals of all genders the same for equal work. EEOC and FCHR, the Equal Employment Opportunity Commission, and the Florida Commission on Human Relations are the federal and state agencies that are charged with ferreting out discrimination in the workplace. The DOL is the Department of Labor. Those are the government agents that you never want to have knocking on your door, because they will show up with their badge and they will say, show me all your payroll records. And that's never a fun task to go through. The FMLA is the Family and Medical Leave Act that provides for up to 12 weeks of unpaid job protected leave for a variety of things, including an individual's own serious health condition, the serious health condition of a family member, birth of a child, adoption of a child, and certain military leaves. GINA is a lesser known anti-discrimination law. It's actually the newest. And I say new, and I mean 2008 at this point, so it's not very new. But GINA is the Genetic Information Non-Discrimination Act, and that made genetic information a protected class, which we'll talk about. And then one of our COVID acronyms, FFCRA, the Families First Coronavirus Response Act. And that is the law that was enacted back in April of 2020 that required employers to offer paid leave for coronavirus-related issues. It's no longer in effect. It sunset officially at the end of December of last year. Some of the provisions survived for a bit, but the FFCRA is no longer applicable, at least as we sit here right now. Okay, one of the things that I think is really important to know if you're dealing with employment laws, or as an employer, as a mediator, is what laws apply to what businesses. Typically in employment law, we look at the number of employees. And that's one of the first questions that I almost always ask when I have a new client. How many employees do you have? Because that's how I know which laws they're going to be subject to. If I have a very small business, for example, call me and say, hey, I've got, somebody's making a disability or an age discrimination claim against me, I will say, well, how many employees do you have? And if they say I have 8, then I say, well, lucky you, you are not subject to the age discrimination laws. So that is one of the first things I will always look at. Some laws will apply, and this is of course not an exhaustive list of every employment law. That would make my job way too easy if this was it. But some of the more common ones, more important ones, anybody who has an employee, any employer can be subject to the Florida Minimum Wage Act or the FLSA, the Fair Labor Standards Act, subject to some coverage issues in the FLSA. So basically all businesses that have an employee are subject to the Florida Minimum Wage Act or the FLSA, again, subject to some coverage issues like if you don't gross at least $500,000 a year, you may not be covered by the FLSA unless your employee or employees are using instrumentalities of commerce. So that's a real fun analysis to go through. USERRA, against the military leave, that applies irrespective of the number of employees you have. Once you get to 10 plus, now you're covered by the Private Whistleblower Act, the Florida Private Whistleblower Act. 15 plus is where you really start getting into the meat of employment law. So that's when you become subject to Title VII, which is the Federal Civil Rights Act, and the FCRA is the Florida Civil Rights Act. So once you hit 15, you're going to be subject to those, which means your employees have protections under those laws. 20 plus is the age discrimination, the federal age discrimination law. And then for larger employers, or at least Southwest Florida size larger employers, once you hit 50, you're subject to the Family Medical Leave Act and ACA, the Affordable Care Act. So that is the health insurance law that I always say I don't do benefits. There are people who do and specialize in that, and I know better than to dabble in that. So those are just the basics of the applicability of the various employment laws. What are some of the most common employment law claims we see? I would say, at least as long as I have been practicing employment law, wage hour is the most common claim that we see. I think there's a lot of reasons for that, and I'll talk about them on the next slide. Retaliation is actually the #1 filed claim with the EEOC. Again, the EEOC is the Equal Employment Opportunity Commission, and they track their charges that they receive, and their charges they receive on protected classes, harassment, discrimination, retaliation. And retaliation is the #1 filed claim for as long as I've been paying attention. So it's been a long time now that retaliation has been the #1 claim. In addition to retaliation claims that make their way to the EEOC, you can have retaliation claims that don't even fall under the jurisdiction of the EEOC, like whistleblower claims. They don't have to go to the EEOC first. So I think retaliation, you can also have work comp retaliation as an example. If you have an employee who makes a work comp claim and then they get fired close in time to that work comp claim, they could bring a retaliation claim. So retaliation is definitely one of the more common claims that we see. And then discrimination or harassment. I think oftentimes people think when they hear employment law, naturally, I think they think about discrimination and harassment. And we certainly do get a lot of those claims, but they're not as common as you would think. And in my opinion, at least in my practice, not as common as the wage hour and retaliation claims. Whoops, I went a little fast on that. So why do we care about wage hour? And this is a joke. I always joke, any defense lawyer in the employment law world can't talk about wage hour claims without talking about Morgan & Morgan, because as I said a second ago, number one claim that I deal with, and the large majority of the opposing counsel that I deal with on wage hour claims are from Morgan & Morgan. So I say that with a loving little needle and not with any disrespect. My little caveat to anyone who is concerned about this is that they have really good lawyers. All the wage hour lawyers, I don't know why they don't have any here based in Fort Myers of the wage hour lawyers, or the employment lawyers. They're mostly based over in Miami, and I've become really close to a couple of them, and they're great people, great lawyers. And I do enjoy working with them, but so this is all in jest, but we do see lots of Morgan & Morgan wage hour claims. Why are they so dangerous, and why do I think that they are one of the most common filed employment claims? Number one, the law is complicated. I often say that even though I do employment law every working day of my life, I still sometimes get out books. I don't really get out books anymore because everything is online, but I still look at my resource materials when the issues get complicated, just to make sure that I'm giving the right advice. And for a business owner who is trying to run their business and focus on their own, business, it can be very easy to innocently make mistakes that violate the law. Thankfully, most of what we see are not egregious situations where employers are just failing to pay people or, intentionally not paying overtime. It's more common to be an innocent mistake, but it can be a mistake that's very costly. Part of that reason is because of liquidated damages. So liquidated damages in the wage hour world and the FLSA world are double damages. And it's very difficult if you have liability under the FLSA to get out of paying liquidated damages. So let's say you've got $1,000 that are owed to your now former employee, you're almost automatically going to now be paying them $2,000 plus the attorney's fees. So you're paying your attorney, you're also paying the plaintiff's attorney. And typically it's not a contingency type relationship where the plaintiff's attorney's fee comes out of the settlement amount. It's usually tacked on top of the back wage and liquidated damages award. And then the FLSA is one of the few areas where supervisors and business owners can be sued individually in employment law. So most employment laws do not provide for individual liability. There are some others that do, but most of them do not. So then you have a situation where if somebody, an employee, former employee, wants to bring a claim, they're generally bringing it against the business. That's not the case in the FLSA. It is very common for plaintiffs to sue the business and to sue the business owner, the HR professional, the supervisor, whoever it is that has control over the wage hour decisions with respect to that employee. So those are some of the reasons why wage hour claims are so dangerous. What are some of the basics of a wage hour claim? So if I could tell any employer one thing about employment law or about wage hour law, it would be, do not assume that just because you pay somebody a salary that they are exempt and not entitled to overtime. It is a very common misconception for people to think that just because someone makes a salary, they don't have to be paid overtime, and that's not the case. That's one of the requirements, to make sure that they don't have to be paid overtime. But in order to actually be exempt, and that's the concept, it's exempt versus non-exempt, and it literally means exempt from minimum wage and overtime requirements, or not exempt from minimum wage and overtime requirements. If an individual is not exempt from minimum wage and overtime requirements, they have to be paid at least minimum wage, and they have to be paid time and a half for all hours worked over 40 in a work week. And a work week is a 7-day period, irrespective of how often you pay. So you can have a biweekly payroll, that's perfectly lawful, but you have to calculate overtime on a week-by-week basis. So you have to be looking at the same 7-day period every single week in order to determine whether somebody has gone into overtime. With the exception of a couple of industries, you cannot do an 80-hour work week to determine whether somebody is entitled to overtime. In order to be exempt, there are certain requirements that somebody has to meet. So there's 2 tests for most of the exemptions, and certainly for the most common exemptions. There's the duties test, which of course, because nothing can be completely simple, the duties test is different for each exemption. And then there's a salary basis test. So somebody has to meet the duties test for each exemption, or for whatever exemption that you believe they're qualified for. And they also have to meet the salary basis test. What is a salary basis test? So the salary basis test is that an exempt employee must be paid the same salary every single week, irrespective of the quantity or the quality of their work. So that means that for an employee to be properly exempt, they have to make the same salary, whether it's $1,000 a week or the minimum salary, which is $684 currently, $684 a week. They have to make that same salary every single week, with very, very limited exceptions. So they would make, just say for argument's sake, $1,000. Let's say that they work 30 hours in one work week. They still get paid $1,000. If they work 70 hours the next work week, they still get paid their $1,000, again, with very limited exceptions. You might notice that I highlighted lawyers on here. The salary basis component of the exemption test does not apply to lawyers, doctors, teachers, or outside sales. Of course, lawyers would write themselves out of that. What does that mean? That means that in theory, you could have a lawyer or a doctor or a teacher who, as long as they meet the duties test for the exemption, you don't have to pay them that minimum $684 per week. So the salary basis test does not apply to certain positions. Some of the common exemptions, the first 3 are by far the most common, the EAP exemptions, executive. The executive exemption is the management exemption. It is, I think, probably the most common exemption. Somebody is not automatically exempt just because you give them a manager title or an assistant manager title and you pay them a salary. They have to supervise at least 2 or more employees. They have to have either decision-making authority or significant, their decisions or suggestions have significant weight in hiring, firing, scheduling, pay, things like that. So it's not enough to just attach a manager label and pay somebody a salary. The administrative exemption is a misnomer. It doesn't mean clerical. It means office or non-manual work that's integral to the business's operations. So for example, the administrative exemption is where a lot of financial employees will be exempt, like controllers, HR professionals, marketing professionals, but they still have to have significant discretion as to matters of significance is the test. So this is not just your lower level controller, lower level HR professional, lower level marketing person. It's somebody who is really in charge of that department for your business. Professional exemption is doctors, lawyers, teachers, the learned professional exemption. It's an advanced degree, science or learning. There's also a creative professionals exemption. Doesn't pop up that often, but can be applicable to people like interior designers, graphic designers, actors, things of that nature. Outside sales is somebody who is truly outside selling. So literally like door-to-door sales is essentially what it requires. And then computer professionals, and those are people who high-level computer, like programmers and things of that nature. So those are the most common exemptions. What are some of the most common problems we see? Misclassification. And there's 2 ways that a business, or at least 2 ways that a business can misclassify an employee in the wage hour world. The exempt versus non-exempt classification. So again, paying somebody a salary basis when they're not really exempt from overtime. That is more common than employee versus contractor. And it is very, very dangerous when it happens, because typically when you pay somebody a salary, you're not tracking their hours, and you're not required to if they are actually legally exempt. But let's say you have a situation with a misclassification where you thought that your manager was exempt and you were paying them $50,000 a year and you weren't tracking their time. If they get upset with you and they sue you and they claim they were misclassified, they are going to allege generally that they were working 50 hours, 60 hours, 70 hours a week, and you're not going to have records generally to prove them wrong. So the court is going to essentially take their word for it. So when you have somebody that is going to be able to claim they were working, 20, 30, 40 plus hours of overtime every single week, when you add in the liquidated damages and the attorney's fees, that can be a very, very expensive misclassification. Also, and this is going to become more and more true under the Biden administration, the misclassification of employees versus independent contractors. So a W-2 employee versus a 1099 contractor. And I have a slide for that next, so I'll save it for that. Improper deductions, that comes into play when you have an exempt employee. Like I said a couple minutes ago, there are very, very limited times when you can deduct from an exempt employee's pay. It's convoluted, too much for me to get into on this presentation, but just know that the basics of the exemption require you to pay, or an employer to pay, the full salary every single week, irrespective of the quantity or the quality of the work. Probably the most common issue that we will see is off the clock work. So this will be when you have a non-exempt employee who should be tracking all their time and who should be paid overtime, but they are not recording time, or they're not allowed to record time, or they're not properly recording their time for things like pre-shift and post-shift work. So for example, let's say the shift starts at 8 o'clock in the morning, but they're coming every day at 7:45 and they're starting up their computer and they're starting to do work, but they're not clocking in. Every 15, that 15 minutes every single day can add up if they're not being properly paid. Travel time's another relatively common issue, and that comes into play primarily when you have somebody traveling during the workday. So if you have multiple locations and they're traveling during the workday, that time should be paid time. Generally, the commute from home to work in the morning and from work to home in the evening is not counted as work time unless the employee is performing work, or they're picking up supplies, or something of that nature. Electronic devices. If you have non-exempt employees who have access to their email after hours, and they are actually responding to substantive emails and it, that can be an issue if they are not being paid for that time. Breaks. There's a relatively common misconception about the requirement to give breaks. There's actually no requirement in Florida except for certain minors to give breaks. So you're not required to give a break every 4 hours or every 8 hours, or you're not required to give a meal period, again, unless for certain minors, but for anyone of age, you're not required to give breaks. However, if you do, there are requirements with regard to how you have to pay them. If it's a short run-of-the-mill 10 or 15-minute break, that always needs to be paid. That's what the Department of Labor will tell you. In order for a meal period to be unpaid, it has to be at least 30 minutes where the employee is completely relieved from duty. So no emails, no phone calls, no reading documents. They're completely relieved from duty. And this is non-exempt employees, of course, completely relieved from duty, not performing any work for at least 30 minutes. If they only get 25 minutes and you have automatically deducted that 30-minute lunch period, that can be problematic. If they get 25 minutes instead of 30, you lose the entire period as unpaid time. So make sure if you do unpaid lunch periods or meal periods that you are making sure the employees have at least 30 minutes where they're completely relieved from duty. Contractor versus employee. So again, this goes back to the 1099 versus the W-2 employee. This is a very dangerous area of law, especially now. It's interesting in the employment law world because you can see trends as different administrations come and go. When there is a Republican-controlled White House and or Congress, you tend to see a lot more business-friendly, employer-friendly laws, and the reverse is true when you have a Democratic-controlled White House or Congress. You see more employee-friendly employment laws. That's true with respect to classification. In fact, the newer, I guess it's not completely new now, but the new administration has already rescinded a couple of Trump era Department of Labor rulings. They have upped the enforcement of the misclassification as individuals, as independent contractors. There's a zillion different tests for what is, or what is an independent contractor and what is an employee. The IRS used to have its 20-factor test you may be familiar with. They don't use that anymore, but they have their own tests. The Fair Labor Standards Act has a test. Florida DEO, which is the Department of Economic Opportunity, which does unemployment or reemployment, has its own test. ERISA has a test. My favorite test, if it looks like an employee, if you treat it like an employee, if you pay it like an employee, it's an employee. Don't try to classify the person as an independent contractor. If they're doing, your work, the same work that you're paying employees for, be really, really careful, because you don't want to get into a situation where you have misclassified somebody as an independent contractor. Why is that? Because there can be significant consequences. If there is a misclassification and it comes to light, you have to worry about the IRS, who's going to come looking for you for back taxes, that the percentage that we all pay on Social Security and your FICA taxes. There can be penalties involved if you've misclassified somebody. There can be wage hour claims for back wages, liquidated damages. You can get hit for the reemployment or unemployment taxes that the government says you should have been paying in, both on a state and a federal level. And then there can be consequences with the discrimination laws, because generally with discrimination laws, independent contractors are not protected. However, employees are. So there can be all sorts of consequences with a misclassification. So it is a very, very dangerous area, if you will, for employers. All right, so going back to what our most common employment law claims are, that was my long-winded wage hour section. Again, most common file claim that I see, at least. Next, we have retaliation. So retaliation, one of my memes again. Yes, he harassed me. That's terrible for you, especially because now I'm going to fire you. So that is a classic example of retaliation. If that actually happened, that would be a very dangerous claim. So what is retaliation in a nutshell? So in a nutshell, retaliation is somebody engages in protected activity, they suffer an adverse employment action, and there is some sort of causal connection between the two. So for example, like the work comp example that I gave a couple minutes ago, somebody falls and hurts themselves at work, they make a work comp claim, and then a couple weeks later you terminate them. You could have a really good reason for termination, but based on that timing alone, the temporal proximity, you may have a retaliation claim on your hands because of that protected activity. What are some examples of protected activity? So an employee opposes unlawful activity. So you've got a whistleblower. Whistleblower claims are actually becoming more and more common. I'm not entirely sure why that is, but it seems like I have been getting an increase in both public and private employer whistleblower claims. You can have an employee who complained about discrimination or harassment, complaints about hours, schedules, wages, work comp claims, or somebody who needs medical leave or FMLA or a disability accommodation. So those are some examples of protected activity. So again, going back to the elements of retaliation, someone engages in protected activity, you can't take adverse employment action against them because of that protected activity. And adverse employment action is broader than just hiring and firing. So it can be a material change in the terms and conditions of employment for purposes of adverse employment action. So a reduction in wages, a reduction in their schedule, or giving them a worse shift or something along those lines can constitute an adverse employment action. All right, so then the final example of some of the most common employment law claims, discrimination and harassment. So what's this I hear about you filing an age discrimination suit, you old fool? I usually joke when I put this up that if that actually happened, that conversation happened, that would be a very compelling testimony in your age discrimination trial. What are the basic elements of discrimination? So you have a member of a protected class who suffers an adverse employment action, and they are treated differently from similarly situated employees outside of their protected class. So we talked about or I talked about, adverse employment action. Same thing with retaliation. It's not limited just to hiring and firing. An action can be adverse when it is any material, substantial change in the terms and conditions of their employment. And then I'm going to go back to protected class, but the similarly situated element, and these are not technically all of the elements, but these are the basic ones that I think are really important for every employer to know. The individual is treated differently from similarly situated employees outside of their protected class. So, for example, let's say you have a gender discrimination claim. You would want to look at, is that person being treated similarly as other individuals of a different gender? So a female could say, well, I am equal in all respects or similarly situated in all respects to John Doe over here, but John Doe is making more money than I am. And so if the individual could show that she is being treated differently than John Doe, and the only real difference is their gender, that would be the similarly situated element. And then protected classes. So you often, if you ever look at employee handbooks, you'll see a policy that says, the employer does not discriminate on the basis of, and there's this long list of protected classes. The protected classes that Florida employers should know about: race, color, national origin, age, gender, which now includes sexual orientation and gender identity. That's thanks to the US Supreme Court back in June of 2020. So prior to June of 2020, there was not a federal law or a Florida specific law that protected sexual orientation or gender identity. But as of June of 2020, in a trio of cases that made their way to the US Supreme Court, the US Supreme Court has officially spoken and said, yes, sexual orientation and gender identity are protected under gender. So you can't make employment related decisions based on somebody's sexual orientation or gender identity. Pregnancy is protected, religion is protected, disability, marital status is a Florida specific protection. What that means is you can't make an employment related decision based on whether somebody's married, unmarried, widowed, or divorced. What it does not mean is it does not protect the specific identity of somebody's spouse. So for those of you, many of you I'm sure know my husband, John Agnew, who of course I love very dearly. But when I'm explaining marital status discrimination to supervisors and other people that I do this training for, I give an example about John, and I'll say, let's say I want to get a job at whatever business and I want to be an HR person or employment lawyer there. And the employer says, well, Suzanne's married. We don't really want to hire married people. They're no fun. We'd rather hire single people. Can they do that? No, because that would be unlawful because they're making a decision based on my marital status. But let's say same business, I go and I want to get a job there and they think I'm qualified and think they want to hire me until they meet John Agnew. And they decide, we like Suzanne, but we don't really like John Agnew. We don't want him coming to our holiday parties. We don't want him roaming our hallways. He's, kind of just a weirdo. Can they refuse to hire me because they don't like my husband? Technically, yes, because the specific identity of somebody's spouse is not protected. So that's the marital status discrimination. And I did actually, just for the record, get to do this presentation in front of John once, because as many of you know, he serves as the city attorney for Sanibel, and I've done some training out there. So it was fun to get to do it with him in the room. And then the last protected class is genetic information. I mentioned GINA a few minutes ago, the Genetic Information Non-Discrimination Act. And usually when I talk about genetic information, I'll get this look like, how would I ever know what that is? Like, why would I ever know somebody's genetic information? And the reason that matters in the employment law context is because when the law was drafted, the definition of genetic information was drafted broadly enough to include family medical history. So you can't make an employment related decision based on somebody's family medical history. So those are the protected classes. Again, we're talking about most common employment law claims. Discrimination and harassment can be unlawful when they are based on any of these protected classes. One thing that I think is important, and I could see this popping up in mediation sometime, let's say, what's the difference between a really bad supervisor or a really bad employer and something that actually could be unlawful? So let's say you have a supervisor in the accounting department who constantly and publicly criticizes his employees and calls them stupid and lazy. Is that unlawful, or is that just a really bad supervisor? It's not unlawful because it's not based on a protected class. It's a really bad supervisor. It's not an environment you want to have. But look at the difference here. The same accounting supervisor refers to one of his employees as an old gal who is over the hill and has problems using a computer because of her age. This in and of itself, not going to constitute unlawful discrimination, but you can see the difference between a really bad supervisor calling somebody names and a really bad supervisor calling somebody names that are related to a protected class. So that's the difference. You never want to have either of those as an employer or, you know, as a business owner, but only one of them has to do with a protected class. Okay, 5 things I think mediators should know about employment law. There is no such thing as a 1099 employee. That is probably one of my biggest pet peeves. There is no such thing as a 1099 employee. So somebody is either a 1099 independent contractor or they are a W-2 employee. And if you ever have a business or an employer or whomever in your mediation who says, I have a 1099 employee, that is not correct. If they have an agreement in writing that says they're a 1099 employee, that's not correct. It doesn't matter. There is no such thing as a 1099 employee. You are either an employee or you are a 1099 independent contractor. That is a really, really common misconception, and it's one that really truly generates a lot of problems for employers who don't necessarily know better. Thing number 2, somebody cannot legally be paid under the table. So what makes this really interesting, and I know this has popped up in a couple of my cases, is if somebody is being paid under the table and they're accepting that payment under the table, that is dangerous for both sides. So it's not just the employer here who stands to get in trouble. Everybody's avoiding paying taxes in this situation. And that's why you can't legally pay somebody under the table, because you are not paying taxes, you are not taking taxes. So if you have somebody in your mediation who is being paid under the table, just know that irrespective of what side of that table they are sitting on, that is very dangerous, very risky. And in fact, I know of situations where attorneys have actually had to, withdraw or not represent somebody further because of some of the things they learn about people being paid under the table. So it is not legal to pay anybody under the table on either side, not legal to pay or be paid under the table. On a more serious note, what role does an employer play with respect to its employees' domestic issues? So divorce, domestic violence, child support. There's only one law specifically that applies to domestic issues, at least in the employment context, and that's a Florida statute that protects victims of domestic violence. And it only applies to employers who have at least 50 employees in Florida. But if you have a business that has more than 50 employees, they have to provide up to 3 days of unpaid leave, job protected leave, to employees who are victims of domestic violence or who need to seek services in connection with domestic violence, whether that's legal services or services from a shelter or something like that. So for the larger employers, there are protections in that respect. Other than that, generally, the employer stays out of domestic type issues, but some of the things that employers should be aware of, if you have an employee who is struggling with domestic violence issues, you want to make sure that you are taking appropriate measures to protect your employees in general. If you have a situation, I've had a couple of clients who've had to deal with threats from divorcing spouses or from former spouses. And what I would say to that is don't ever hesitate to get law enforcement involved if you need to, because you have an obligation as an employer to protect your employees. So you want to make sure that you are doing so. Employers oftentimes can have to get involved in producing documents for litigation on their employees for divorces and things like that. As long as the attorney has followed the right process with respect to notices of production and no objections and things like that, you can produce the entire employment file, including medical information. Garnishments sometimes come into play that employers have to deal with, But generally speaking, you know, the domestic violence law is the one specifically that applies to employers. Number 4, know that wrongful termination case is probably not worth millions of dollars. So if you have somebody in a mediation who is wanting to, you know, believe or make you believe or make the other party believe that they have this wrongful termination case that's going to make them rich and, you know, let them retire on Richard Branson's private island, most employment cases are not $1 million cases. They're just not. It's very rare in the employment context to have a case that, you know, frankly, even gets into the 6 figures, much less the high 6 figures or even into the 7 figures. It happens. Don't get me wrong. It does happen, but it's very rare. It's not like a, you know, personal injury case with a very severe injury where it's more common to see, you know, significant life-changing settlement amounts or verdicts. They do again happen in employment law, but it has to be typically really egregious facts, a high wage earner, so you can get, you know, significant back wages and front pay. But generally speaking, wrongful termination is really any employment claim except for certain wage claims is not going to result in, you know, super high 6-figure, 7-figure recovery. And then number 5, one of my favorite COVID era memes, Hipaa versus Hippo. How is health information really protected in the workplace? So here's one of my favorite memes that I have seen floating around the HR and employment law world. During COVID especially, and when the vaccine mandates started to, you know, come down, and when employers were requesting proof of vaccination and things like that, I can't tell you how many clients I had or how many people were commenting on social media who said, that's Hipaa. My employer doesn't have a right to ask me about my medical information. That's Hipaa. I'm protected by Hipaa. And they would spell it wrong, or hippo, hippopotamus. Whoever came up with this chart, I think, is brilliant because I really got a good laugh out of it. But Hipaa, in large part, does not apply in the workplace. So what does that mean? Your employer, or you as an employer, or your party in mediation as an employer, is absolutely entitled to know information about its employees. An employer is entitled to know why an employee is missing work. Does that mean that the employer should go, you know, call the employee and say, what's your diagnosis? No, you shouldn't do that. But if you have an employee who is missing work, you absolutely are entitled to know why they're missing work. And if they say it's because of a health-related issue, you're entitled to some additional information on that. There is no HIPAA protection that would prohibit an employer from asking questions about an employee's medical status. Now, an employer does have an obligation to keep any medical information that it receives confidential. So there's protections under the ADA for the medical information that an employer receives, but there is no HIPAA blanket prohibition on an employer asking for medical information. As another little tidbit, especially as an employer, if you do receive information, medical information about an employee, then you have to make sure you keep that confidential and keep it separate from the employee's personnel file. So put it in a separate file. Doctor's notes, FMLA requests, anything of that nature should be kept separate from a personnel file. One little bonus things I think mediators should know about employment law. The First Amendment does not apply to private companies. So also a very popular, not only during COVID, but last year when a lot of the racial and social justice issues were coming to a head. A common theme that I would hear from employers or on social media would be, my employer can't take action against me for what I say on social media, especially on my own time. The First Amendment, I have free speech rights. No, you don't. Yes, you have free speech rights from the government. So the government can't stop you or arrest you or anything of that nature. But private employers, the First Amendment does not apply to prohibit private employers from taking action against their employees for statements that they make on social media. And that includes statements that are made off hours. So if you have an employee who is making racist comments or, you know, otherwise inappropriate comments, you absolutely do not have to worry about First Amendment protection in the private workplace. So that is a common misconception that I see. All right, so that is my rambling. I am going to look in the chat and see here. Oh, one of the questions I received was, how can I find the most current contractor independent contractor test? So you would need to know which one you're looking for. So the IRS actually, like I said, got rid of the 20-factor test, but they have some information on their website about what they look at. It comes down to control. So I would look at the IRS website, and then the Department of Labor also has a section, and I'm actually not sure offhand if that has been updated recently, but the Department of Labor actually publishes really helpful fact sheets, so FACT fact sheets, on a variety of wage hour topics. So they have all the exemptions on there. They have some things like independent contractors. So if you look to DOL fact sheets, if you're interested in the exemptions, I would highly encourage you to take a look at those, download them. They're really easy to understand, and they at least used to have one on independent contractors. So those are the two primaries that I'd look at, the Department of Labor and the IRS, and see what resources they have current on their website, because they do change from time to time.
I have a question, Suzanne, if I may. I saw that gender identity is now a protected class, if I use that term correctly. Does an employer have to know what the gender identity is in order to be subject to discrimination? And it would not the very act of discovering the gender identification be problematic?
So it's a really good question, and this is an area that is becoming more and more common, honestly, for employers to wrangle with in the workplace. And to the first question, yes, in order for the employer to get in trouble, if you will, for gender identity discrimination, they would have to know what the person's gender identity was, because in order to get in trouble, they would have to be making an adverse employment action based on that gender identity. One thing I will say is, you're not required to just assume the gender identity. But if somebody comes to you and says, and I've had several clients who've had to work through this, if somebody comes to, for example, and says, I'm going to be transitioning from male to female, for example, I was born biologically a male, but I identify as a female, and I'm going to be undergoing a transition, you're definitely on notice at that point. And there are certain protections that an employer would have to provide. And it gets really interesting when it comes to bathroom access, use of pronouns, use of name tags, and things like that. So it is a developing area of law. It is one that is becoming, again, like I said, more common for employers to have to address. It requires a lot of sensitivity, lots of education, lots of training for supervisors and other employees, so you don't get it wrong. But yes, to answer the question, you would have to be aware of the person's gender identity in order to get in trouble for it, if you will.
Thank you. Great explanation. Appreciate it.
I don't see any other questions, so I think that's all for me, unless somebody wants to chime in. If not, Anne, thank you for inviting me to speak. I really appreciate it, and thank you all for appearing. And hopefully I will see some of you or all of you in person sooner than later.
Well, and I thank you for doing this, because it's an area of law that mediators run into sort of sometimes in little quirky ways. And while we're obviously not the quasi-judicial or judicial person, but it's always good to have all that extra knowledge under your belt. So Suzanne, I really, really appreciate what you did. And everyone, thank you for coming, and we'll see you next time. Thank you.
Take care, everybody.